Hey guys, and welcome back to the channel. Today we have something truly special lined up for you. A once-in-a-lifetime cosmic alignment of stupidity, so rare and so beautiful that scientists are still struggling to explain it. We have not one, not two, but three red flags walking into a courtroom on two legs. We've got a Karen. We've got a sovereign citizen. And she has fired her own attorney and decided, against all logic, reason, and basic self-preservation instinct, to represent herself in a probation violation hearing. Buckle up, because this one is going to be a ride.
State versus Ashley Clark, 22 CR 216. Mr. Fosgrove.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
I got this myself. For words. For little words that have preceded more disasters than perhaps any other phrase in the English language. Right up there with hold my beer and what's the worst that could happen? These are the famous last words of every single overconfident Karen who marches out of the house without so much as a helmet, a map, or a single functioning brain cell to guide her. So let's set the scene. She had a lawyer, a real, actual, licensed attorney, someone who went to school for years, passed the bar exam, and most importantly, had already negotiated a deal for her. A deal that would have kept her out of serious trouble. And what did she do with that deal? She looked at it, decided she knew better, fired her attorney, threw the deal straight in the garbage, and announced to the court that she would be handling things herself from here on out. I want you to really sit with that for a moment.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them. But you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well. And that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence, just as if you're an attorney. You understand that?
Yes, sir.
All right. Does anyone promise you anything or threaten with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay. State has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right. Ms. Clark, any opening statement?
No.
Now look, I'm not a heartless person. Part of me genuinely wants to root for the underdog. And there is something almost admirable about the sheer, unshakable confidence this woman is radiating right now. She is certain. She has walked into this courtroom like she owns the place, like she has already won, like the judge should probably just go ahead and thank her for her time. The problem, of course, is that this confidence is not rooted in anything resembling reality. It is the confidence of someone who watched a few YouTube videos at 2 a.m. and came away feeling like a constitutional scholar. It is the confidence of someone who has never actually been held accountable for being wrong before. And that, my friends, is precisely why I find it so entertaining. Because today, the accountability is coming, and it is coming fast. The prosecution, recognizing that their job here is going to be embarrassingly easy, is now calling their one and only witness to the stand. Just one witness. That's all they need. Ladies and gentlemen, please welcome to the stand her own probation officer.
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample from Miss Clark?
it was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines.
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
Here is the fundamental problem with the sovereign citizen movement that nobody who joins it ever seems to figure out until it's far too late. The gurus, the YouTube lawyers, the Facebook philosophers, the self-proclaimed constitutional experts who have never once set foot inside an actual courtroom. They are great at one thing and one thing only: teaching their followers how to fire their attorney. That's the whole playbook. Fire your lawyer, declare yourself a sovereign, throw around a bunch of legal-sounding words, and somehow the system will crumble before you. What they conveniently leave out of their 3-hour video courses is literally everything that comes after that. Because here's the dirty little secret of the sovereign citizen movement. Nobody has ever actually won using these tactics. Not once. It is, to this day, completely uncharted territory. There is no roadmap, no case study, no success story to point to. So what happens when a sovereign citizen actually has to stand up and defend themselves in court? They improvise. They ramble. They cite laws that don't exist, reference documents nobody has ever heard of, and generally make things so much worse for themselves that the prosecution barely even has to show up. Today's crash test dummy is about to demonstrate this phenomenon in real time, and honestly, I couldn't be more grateful.
All right. Do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right. Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument.
So let's take stock of our legal strategy heading into closing arguments, shall we? Did we challenge any of the evidence the state presented against us? No. Did we object to anything? No. Did we cross-examine any witnesses in a meaningful way? Absolutely not. Did we present any evidence of our own? Not a single shred. Did we call any witnesses? No. Did we do anything that a reasonable person might describe as a legal defense? I think you know the answer. What we have done is show up, make some noise, and radiate the energy of someone who genuinely believes that the vibes alone are going to carry the day. And now, with closing arguments upon us, we are about to find out just how deep this commitment to the bit really goes. This is our final opportunity to gauge, with scientific precision, exactly how many crayons this woman can fit in her mouth at one time. I have popcorn. I am ready.
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
5-0, Karen. Sweet, sweet Karen. There's an old saying, play stupid games, win stupid prizes. And while Karen has clearly heard this phrase before, she has not, apparently, applied it to herself. Because right now, in her closing argument, she is standing before this court and expressing her deep concern about the IRS. The IRS. Karen, with the greatest of respect, and I do mean the greatest, the IRS is not in this room today. The IRS did not file this case. The IRS is not the one who has been presenting evidence against you for the past hour. The entity that is currently in the process of ending your day is the state of Kansas. They are the ones who would very much like to have a word with you about your probation violations. The IRS can absolutely get in line, but they're going to have to wait their turn. She played the game. She made her moves. She rolled the dice with both hands tied behind her back. And now, ladies and gentlemen, it is time. It is finally time to find out exactly what stupid prize she has won.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve her sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
$1,200 a minute for every single minute she spends in jail. Let's just run those numbers real quick, because I think we owe it to ourselves to fully appreciate the scale of what we're looking at here. $1,200 a minute. That's $72,000 an hour. That's over $1.7 million a day. That is, by any reasonable measure, a lot of cheeseburgers, Karen. A life-changing, generation-defining, astronomical number of cheeseburgers. Maybe, just maybe, the lawyer would have been worth keeping around after all. Alright guys, that is going to do it for today's video. The moral of the story, as always, is pretty straightforward. If you are facing legal trouble, please, keep your attorney. Public defenders exist for a reason. The legal system is complicated. It does not care about your feelings, and, I saw it on YouTube, is not a recognized legal defense in any jurisdiction on earth. If you enjoyed today's video, smash that like button and leave a comment below. I read every single one of them. If you didn't enjoy it, leave a dislike, but drop a comment anyway because engagement is engagement. And make sure you subscribe and hit the notification bell so you never miss a video. I'll see you in the next one.